Good morning, everyone. First of all, the Critical Race Studies program at UCLA acknowledges the Tonga peoples as the traditional caretakers of Tavangar, the Los Angeles Basin and Southern Channel Islands. As a land-grant institution, we pay our respects to the ancestors, elders, and our relatives and relations, past, present, and emerging. I'm Jasleen Coley, and I'm the Executive Director of the Critical Race Studies program, and it is such a joy and such a profound honor to welcome you to UCLA School of Law for our 25th anniversary program of the CRS, the Critical Race Studies program. So 25 years ago, a group of visionary faculty, students, and alumni came together to do something unprecedented, to build the nation's first law school program dedicated to critical race theory. They did it in the wake of attacks on affirmative action in California. They did it in a climate where racial justice was dismissed as not worthy of rigorous, serious study in legal academia. And they did it knowing that the law has always been both a site of oppression and a site of possibility. What they created has endured. CRS has trained hundreds of lawyers, many of whom are also now here, who now fight in courtrooms, classrooms, legislatures, and social movements. It has produced path-breaking scholarship that shapes debates around the world. And it has nurtured a community, this beautiful community that's here, one that insists on thinking critically, teaching boldly, and transforming relentlessly. And here we are, 25 years later, still in a moment of backlash, still in a world where racial justice, higher education, and democracy itself are under attack. But also still here, still standing, still imagining, still fighting, still building. That persistence, that refusal to be erased, is what we celebrate this weekend. So over the next 2 days, you're going to hear from over 130 panelists. When we first started planning this, and I just want to also acknowledge our amazing Symposium planning committee, which included Jerry Kong, myself, Latoya Baldwin-Clark, Sunitha Patel, who might be here, and Laura Van Schilfgaard and Cheryl Harris. So I had them meet many times over the past year, and when we put out a call for proposals, we're a little worried about, okay, we need to make sure we just advertise it everywhere, that we get, some good proposals. And we did not plan to get the hundreds of proposals that we did. And at first we thought we were going to have 8 to 10 concurrent panels. So then the proposals started coming in, and they were so strong, so creative, so difficult to say no to, that I told the Symposium Planning Committee, okay, fine, I think we can do maybe like 15 or so. And they pushed back, and they said, no. And I said, okay, fine. Maximum, we're doing 20. So we compromised and ended up with 27. Which tells you everything about the brilliance of this community and the people in this room, and also my inability to say no to you all. So, and I am really excited about these panels. You're going to join conversations that really stretch across disciplines. We have people from other parts of campus, other departments, just across generations, our alums, our students. And just across geographies, we have people from around the world who came. You'll witness not just a commemoration of the past, but really, we're going to be talking about a blueprint for the future of race and the law. This gathering is an act of defiance. It is also an act of radical hope. Because we believe, as CRS and our CRT founders did, that law can be reimagined, that communities can resist and transform, that the next 25 years will demand our brilliance, our solidarity, and our courage. So before we begin, a few logistics. You will find the QR codes here on these little handouts that will lead you to the full online program. Please take a look at the full online program. I am just so happy with how it turned out. We wanted to save paper and not print it, but it's made me so happy to look through and see the bios of all these amazing people. So if you get a chance, really just skim through it, because it's so powerful to see just how many of you just brought your intelligence and your heart to this. So thank you. I also hope that you will stay for our dinner reception tonight, which is going to showcase the artistry and the imagination of our students. And it'll be a reminder that transformation also happens through creativity and through our community. And now, just a moment of gratitude. It takes a village to put on a symposium like this, and this symposium was a labor of love by so many people, many of whom were named in our program also, so I urge you to also look at that part. And to our sponsors, your partnership and generosity makes this type of gathering possible. So we're deeply grateful to, just amongst many sponsors, UCLA Law's Williams Institute. I mean, actually in front, you can see that the Williams Institute, we've got the founding executive director coming here at 7 a.m. to work reception and registration. We've got so many of their other staff and UCLA Law's Emmett Institute on Climate Change. When I asked for a few volunteers, they just blew me away with, how much they all stepped up. And so many of our other programs and centers around campus also just stepped up and really, just showed what the heart of our UCLA Law community is, and I was so moved. Also, Nicole Gambino, who is a UCLA Law 2006 alum, who was not even a part of the Critical Race Studies program, was recruited by another student and was just so inspired by the work that's going on here and donated a significant amount. And the law firm of Corey, Luzak, Degat-Taldi, and Riddle. And then there were so many others who contributed at various levels, large and small. It's all been so important. And especially at this moment when racial justice is under attack and when so many donors are afraid to donate and sponsor programs like this, we're just incredibly grateful. And to our volunteers, to the incredible students, staff, and faculty, like I said, again, especially our symposium planning committee, especially our fearless faculty director, Latoya Baldwin-Clark. And also, I have to really give a special thanks to our program coordinator extraordinaire, Ida Hagagatku, who's right here. You might not recognize her here because generally you'll see her as the woman who's just looking frantic and handling everything outside. So everything that's gone well this week is due to her, and everything that doesn't go well is because one of us didn't listen to her. And I was actually just telling one of our other alums, Sarah Kangahi, I don't know if she's here or where she was. I saw her somewhere. Okay, so, but no, I was going to say that I was just reminiscing with Sarah that the last time we had a symposium this large was in 2014 for Professor Cheryl Harris's Whiteness as Property, the 20th anniversary. So perfect timing, Cheryl, we planned that. And at the time, Sarah was a 1L and volunteered to just take care of our reception that we were having afterwards. And then she recruited one of her friends who, wasn't going to law school here. And, she said, yeah, my friend will help me out. And suddenly this woman who we don't know is like taking charge and telling students, okay, you're going to do this, you do this, you do this, and just took over and made this amazing reception out of nothing. And as a former worker rights and labor lawyer, I'm also just really happy that finally now we can pay her for doing that and not just have her unpaid labor. So thank you again, Ida. And finally, just thank you to all of you for being here. I have to say, I got a lot more emotional last night than I expected. Just seeing so many people that I love in one place. Our alumni, raise your hand, alumni. I know there were a lot last night also. At some point, I need to gather for an alumni picture. We've got former faculty who've come back. By the way, also this morning I was texting with Devin Corbato, who during our last symposium, which was in honor of Laura Gomez, his first grandchild decided to be born that day. And now he also has a family event overseas. So I love him and his family, but they keep, just interfering with our symposia. But he sends his regards and his love and is very sad he can't be here. But we have so many of our other former faculty here. We have so many colleagues from other schools and from across campus. We've got our Race and Law Center Network folks here. Raise your hands if you're here. Yes. So this is a community of about 28 race and law centers from around the country, and we try to meet once a year in person and a couple of times virtually so that we can strategize and inspire one another with the work that we're doing. And really, again, just having all of you in the same room, I just have been so emotional. I keep telling people that I need to figure out a way to keep you all here forever. And I just haven't been able to figure out how to make that happen. So if anyone knows a way that's legal and doesn't involve threats or bribery or blackmail or accusations of false imprisonment, let me know, especially for some of the former faculty over here. If their flights get mysteriously canceled, just between us, it was not me. So anyway, I'm so moved to just see all of you here and for the conversations we're going to have that we had last night, that we had at our Race and Law Center Network convening, and that we're going to have over the next 2 days. And so thank you for just bringing your intellect, your commitment, your heart to this. And thank you for standing with CRS at a time when it matters more than ever. And so let's begin. Let's think, let's teach, and let's transform. And send it over.
Good morning. My name is Jerry Kong. I am a professor here. I was back here 25 years ago with Laura Gomez when we were the founding co-directors of the CRS program. I can't believe how long it's been. I am not a sentimental person, as many of you know, but the feeling of community is extraordinary. And there are moments of crisis. There are moments of uncertainty. There are moments where you don't frankly know whether anything you've ever done matters. But periodically you're reminded that it does matter in the people that you've met, in the thoughts that you've had, in the connections you've made. And it is the fight, it is the journey that we've all been a part of, and it's just lovely to see the generations of that going on, and to see, again, the ripples going out from here throughout the country, throughout the world. And I'm here actually with great humility that I played a little part in all of that, and so I'm thankful for everything and all of you. Our first panel is to think bold, new ideas. Branding is a huge part of what we do. Communication is to connect with people in ways that are memorable. Ideas, whether they be intersectionality or any of the concepts like interest convergence that are core to critical race theory, also involves catching a name, catching a phrase, and then keeping that meme alive in people's heads as we actually exchange our ideas. And as we thought about what CRS might be, we thought about what is it that we do. And we did settle on think, teach, and transform. There's a reason why think comes first. I think it's actually incredibly important for us to recognize that this is a serious intellectual enterprise. And part of the thing that has chafed against part of the thing that I've always rejected, indeed been furious about, was the presumption that somehow because it's race, it is not an intellectually serious project, because everyone has a race, everyone could have a comment without thinking about it, because race is something we're used to, it must not be anything besides an emotional reaction towards justice or injustice, and there could not be intellectual content. And I think one of the things that this program has done is to actually challenge that rigorously at every level throughout different topics and subject matter areas as well as different methods. Okay, so in some sense what we're doing is to think about how it is this thing called critical race theory has been applied to different subject areas, the what question, and then how we did it, what kinds of methodological commitments, strategies, tactics might be inherent in critical race theory as we thought of it originally, how it's transformed over time as all intellectual traditions must travel through time and space. And we have an extraordinary group of people who will be addressing those questions, both the what and the how, across different categories. Let me briefly introduce all of them, and they'll go in a certain particular order. The first person to speak will be Laura Gomez. All the bios are in the back. The official title, she has a long one, is Leon Karolitz Chair in Evidence and Procedure at UNM School of Law. She is also the Rachel Moran Endowed Chair in Law Emerita from UCLA. She is one of the people I find closest connection with, because we've been through a lot for over 25 years. After Laura, who is a sociologist by training and who has done an extraordinary amount of important history, we'll next have Asla Bali, who is the Howard Holtzman Professor of Law from Yale Law School. I remember, and Asla will often say that I was, I think, the first person she met when she came in to do the job talk. I helped her through a door. I mispronounced her name. She corrected me. I said, "Oh, hi, Asli." And she said, "No, it's Asla." It's like, "Oh, I'll try to remember." And it's been an extraordinary experience, from the fact that she was, I guess, just a rookie, that we hired, to now fancy, and extraordinarily impressive professor. Footnotes, she's one of the few people who speaks faster than I do. Number 3 will be Ariella Gross, who is, again, in title, a distinguished professor of law and history here at UCLA. She is in some ways an old-timer in the project, but a new person here within the UCLA community. She heralds from another large private law school someplace in Los Angeles. Ariella's commitment to a certain kind of rigor in historical analysis, as well as engaging in, frankly, faculty governance and politics throughout the country, including at this institution, has always been something I have admired, and it's extraordinary to have such a significant lateral hire in the past few years. Finally, we'll have Russell Robinson, who's the Walter Perry Johnson Professor of Law and Faculty Director of Center on Race, Sexuality, and Culture at UC Berkeley. Russell was also in some ways homegrown, and I remember back in the day when Russell actually joined the faculty and the extraordinary path up and unfortunately out, but I'm not going to judge. He has done extraordinary work, and we'll be talking about lots of things. And one of the ways that we overlap, at least in the work that we've done before, is our interest in implicit social cognition and importing certain social sciences into our scholarship. Okay, with that, everyone has 12 minutes. They're going to go in order. I'm not going to reintroduce them, and then we're going to have a conversation, and I'm going to try to pick a fight.
Good morning, everyone. Lovely to see you today. It was lovely to begin last night, and I see some new faces, but it's just great to be here and great to be back, and thank you, Jerry, for that introduction. I want to start by thanking Jasleen and Ida again, and thanking the Faculty Planning Committee and the student volunteers. We can't do these programs without you. I want to just, as a brief introduction, just kind of mark that there have been, to date, 3 phases in the institutionalization of the Critical Race Studies program. And this is what we are celebrating today, because to institutionalize a program means that it cannot be disappeared. Right? And so the first phase Jerry alluded to was 2000 to 2002, when we were volunteer co-directors of CRS, having no idea that we should ask for extra compensation for this honor. And we worked tremendously hard, and branding was one of the things that Jerry was spectacular at. And I remember this brochure, and I'm sure we have copies of it in the archives, and I'm sure I have some in my files, but there was a beautiful brochure that that Jerry really came up with, and the objective was to get the word out to potential law school applicants so that they would apply to come to UCLA at that moment that Cheryl was talking about last night, where our Black and Latino Latinx populations had plummeted. That was the first phase. The second phase was another kind of institutionalization of financial investment by the law school in the form of hiring a program director. And the first was Saul Sarabia, who was here last night. I don't know if I have seen him yet, but you will see him later on a plenary panel. And then the second was Jasleen, who you just heard from. But that meant that they could focus on 2 things, which were incredibly important to the institutionalization of critical race theory as a field and the institutionalization as a program. One, the mentoring and retention of students, and two, the organization of these events, these CRS symposia, right? So the third was, I would put the third to a couple of things, a kind of a crisis period coming up to the present. The first was the crisis of Trump 1, and actually the Trump bump, as we called it, which was a huge surge of interest, and where we became, I think at one point, more than a quarter of all law students at UCLA were enrolled in the CRS program as a specialization. Then followed by COVID, which was a real crisis for our students, a financial crisis, a survival crisis, a retention crisis, as it was for so many in our society, and coming up to this present period. And I just will leave this brief introduction with the thought that we are here this weekend to try to map out and envision the next 25 years of institutionalization of CRS. Okay, so advocacy for a race-conscious as opposed to a colorblind approach to racism has been a central tenet of critical race theory. There has never been a stronger attack on race-conscious viewpoints and race-conscious policies to combat racism than there is today. And these attacks are certainly not limited to the legal sphere, but we can see them clearly in the context of recent Supreme Court events. First, on September 8th, the court in Nome versus Vasquez Perdomo issued a ruling from its shadow docket that allows ICE agents to rely on a person's perceived race as the basis for stopping, questioning, and taking them into custody, so long as race is used in combination with other factors, including location, perceived employment, whether they speak either Spanish or English with an accent, using a totality of the circumstances kind of test. Justice Kavanaugh, in a concurrence, wrote the following, quote, "To be clear, apparent ethnicity alone cannot furnish reasonable suspicion. Under this court's case law regarding immigration stops, however, it can be a relevant factor when considered along with other salient factors." Kavanaugh went out of his way to describe what he called the Los Angeles area in broad terms as all of the Central Federal District of Los Angeles, Ventura, Santa Barbara, San Luis Obispo, Orange, Riverside, and San Bernardino counties, where 20 million people live and work. According to Kavanaugh, quote, "Illegal immigration is especially pronounced," and here he cited the Trump administration's claim that 10% of the people in the Los Angeles area, so defined, are, quote, "in the U.S. illegally." He benignly described the on-the-ground reality in Los Angeles as follows. "The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants and who do not speak much of any English," unquote. Fast forward to 46 days later to the oral argument in the Louisiana voting rights case. The Supreme Court heard the state's attorney general bluntly argue, quote, "We have taken the position that Section 2 of the Voting Rights Act, insofar as it requires race-based redistricting, is unconstitutional," end quote. Kavanaugh questioned our colleague, Janae Nelson, who argued the case for a group of African-American voters, saying, quote, "This court's cases," this is Kavanaugh, "this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but they should not be indefinite and should have an endpoint," unquote. When we put these two cases side by side, what do we see? On the one hand, there's a clear contradiction. Despite the fact that race was only one factor in the state's configuration of a second majority-minority district in Louisiana, Kavanaugh is poised to vote to end race-conscious considerations in the voting rights context. But when it comes to immigration raids, Kavanaugh saves the consideration of race precisely because race is only one of a handful of factors. And we should write, talk, and protest about this contradiction. But on the other hand, there's something else going on. Is the ICE case really about race? Kavanaugh only uses the word ethnicity in his concurrence, whereas Justice Sotomayor, in dissent, followed the district court in using the phrases, quote, race or ethnicity, or apparent race or ethnicity, unquote. Sotomayor slammed the federal government for, quote, all but declaring that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction, unquote. So even Justice Sotomayor qualifies her statement by saying repeatedly race or ethnicity. I want to focus our attention on the fact that in 2025, many, maybe most people in this country are not comfortable with talking about Latinx people in racial terms. At the same time, they are comfortable talking about African Americans in racial terms, often to the exclusion of talking about Black Americans in ethnic terms. In this respect, it is perfectly logical to think about last Wednesday's voting rights case as one about race, and to think about the ICE case as one about ethnicity. But I argue that this is wrong and ignores the history and sociological reality of the Latinx experience. I have spent a good deal of my professional career arguing that Latinx people are racialized as non-white, subordinated people at the structural level in the United States, and I will continue doing so. I've made this argument in two books, Manifest Destinies, The Making of the Mexican-American Race, published originally in 2007 and then in an anniversary edition in 2018, and Inventing Latinos, A New Story of American Racism, published 5 years ago. At the macro level, what we call race congeals from the demographic and cultural registers of the meso level into state-based racial classifications that give rise to processes like racial segregation and racial segmentation in the labor market. To say Latinos are today an American racial group is to say that they are collectively othered and that this racialization process works to maintain white supremacy, both ideologically and materially. In order to combat racism, we must understand the logic of anti-Latinx racism and how it reinforces other racial logics as well as other forms or other bases of oppression. In my remaining few minutes, I will make 3 points that reinforce why we should all view Latinx people in racial terms. First, Manifest Destiny is a cluster of ideas that relied on racism to justify the acquisition of Mexican Texas in the 1830s and the invasion of Mexico in 1846, as well as the subsequent settler colonialism of half of Mexico's northern territory, including where we are right now. Racism was the root of U.S. military interventions in Puerto Rico, Cuba, the Dominican Republic, Panama, and several Central American countries, and racism was used to justify U.S. coups against leftist governments in Latin America over the course of the 20th century, with devastating results in those countries. And it seems that today it is possibly going to be the basis for such intervention in Venezuela and Colombia as well. It was these imperial exploits in Latin America that have for 200 years given rise to the extensive continuous migration of poor people from the Americas to this country to fill low-wage jobs in the most exploited rungs of our economy. 200 years of continuous migration. In other words, for U.S. Latinos, colonialism and migration are on the same continuum. Number two, the white Christian nationalist great replacement theory is built around the idea that immigrants who are people of color are pushing out whites and is, of course, racist. Although traced to a 2011 French author, we see its modern roots in the U.S. in the 2004 book, Who Are We? The Challenges to America's National Identity by the late Samuel Huntington, a Harvard political scientist, and 2 books by the Republican presidential candidate Pat Buchanan in 2001 and 2006, entitled The Death of the West, How Dying Populations and Immigrant Invasions Imperil Our Country and Civilization, and the next book, they all run together, Civilization and State of Emergency, The Third World Invasion and Conquest of America. All 3 of these books were multi-month New York Times bestsellers. It was the, quote, Hispanic invasion that was cited by the white nationalist who killed 22 people at an El Paso Walmart in 2019. Finally, Third, what stoked fears of the great replacement of whites by Latinos was the demographic trends made visible from 1980 onward, when the U.S. Census first counted Latinos, albeit under the guise of an ethnic rather than a racial group. Latinos, who are now 1/5 of the U.S. population, are younger than white non-Latinos and have a higher birth rate. From 2010 to 2020, Latinx people grew at a rate of 23%, mostly by birth, not immigration in the U.S., compared to a growth rate of 4.3% for all other groups combined. Consider that the 2020 census showed that Latinos increasingly think of themselves in racial terms, with 50 million of them choosing the racial category, other race, and rejecting the white-only box. This trend appeared in red and blue states on the West Coast and the East Coast, with Mexican origin as well as Central American as well as Caribbean origin Latinos. And this trend has actually steadily grown for the first time that we counted Latinos on the census in 1980 to 2020. And what I predict is that today's assaults on Latinos will push us even further to identify as outsiders and to think of ourselves in racial terms. And that is the dialectic that we are in the process of experiencing now. Thank you.
Can you hear me? Yeah, this is working. Thank you to everyone. Thank you, of course, to Laura. I should echo Tendai's graceful and eloquent remarks yesterday at coming after Cheryl Harris. But it is always an incredible honor to be on a panel with, in fact, any of the folks who are up here, and all of them at once is overwhelming. But it is also, just a homecoming that makes me incredibly happy. So as Jerry already described, this is certainly home for me. These are people who are really, I feel my career could only have taken shape at this school. And that's a remarkable thing to say in many respects, because I'm the outlier often when I'm at CRS events on a panel, because I work on international law topics, and that's not typically the way we think about the project. And my goal in presenting today, particularly in thinking about how concepts travel and how CRT's influence has really expanded across method, across discipline, and across field of study, is to say all the reasons why actually CRT is very much about the international arena as well. And in saying this, and in beginning in this way, I also want to recognize Tendai Achime, who graciously recognized me over and over again last night in her remarks. Much of what I have to say is going to draw on shared work that we've done that was really made possible again by the fact of being here at UCLA. But the turn to international, I need to proceed by one other thing, which is to say that I was originally formed at a different law school that shall remain unnamed, but in which the word critical appeared nowhere and could never have been appended to any intellectual movement or any set of concepts, and to this day is an uncomfortable fit. So for example, when I proposed teaching a class called Third World Approaches to International Law, which is the name of the intellectual movement I want to talk about today, and the ways in which it has drawn inspiration from and traveled and converged with CRT, I was asked, do you really mean third world? Do you really want that phrase to appear on people's, transcripts? Do you really want this to be the way that you describe your course? And it's an intellectual movement, but even making the space for that claim is challenging. And so being in a room where we're talking about CRT, where focus so far has not primarily been on international, but in which we hear the phrase third world used and affirmed and deployed critically, is itself evidence, as just happened in the speech that preceded my remarks here, is just evidence of the degree to which this is a project that is intrinsically transnational, intrinsically global, that is concerned with, as Kesu Park's remarks yesterday reminded us, colonialism, as Laura's remarks just now also reminded us. It's about this transnational slave trade. It is about the histories of colonialism. And the thing that I'm going to turn to as a concept that has traveled and that has made enormous strides at the transnational and international level, it's about settler colonialism. And it's about the ways in which a transnational network of white supremacy operates globally today that we can only understand by adopting a set of analytic lenses that require us to use CRT. So that is how I want to begin. But then I want to step back for a second to say more about both the intellectual movement that I just mentioned that will not necessarily be familiar in this room, and to say a little more about how CRT expands its frame. So obviously, much of the scholarship on the social construction of race and the role of law in defining and institutionalizing racialized structures of discrimination has its origins with respect to CRT in the study of US law. That goes without saying. But CRT has traveled far beyond that. First and foremost, because other groups and those who have been trained here and returned to other home countries have taken the analytic lens and applied it transnationally. So you have enormous volumes of scholarly engagement and global application of CRT to everything from the experiences of Afro-descendant communities in South America, to Dalit communities in India, to immigrant communities in Europe, to xenophobic discrimination in Africa. So we have seen a global dispersion of the brand CRT and CRS in transnational analyses of race. Now, those analyses have much to teach us, by the way, because race appears differently, is constructed differently, and operates differently as a site of structural discrimination globally, and we have to inform our own understandings of the operation of race by thinking comparatively. And so that's a call that when we get to the fight that Jerry has promised at the end of our remarks today, we can talk about what we can do in institutionalizing the next 25 years that integrates some of those reciprocal lessons, that doesn't just view us as a US exporter of ideas, but also understands us to be in a transnational conversation. But there is also the international application, and that's where I want to focus my remarks today. The specific focus on the role of law in constituting and continually reproducing racial subordination, even in contexts where commitments to formal equality are constitutionally entrenched, which is the core project of CRT, parallels absolutely the accounts of scholars that look at the ongoing relations of imperial subordination in the midst of formal sovereign equality at the global level. That is to say, the object of international law, right? International law is a legal set of doctrines that are about the relations between sovereigns. It has a sub-area of international human rights law that concerns how sovereigns treat individuals, and much of the work has been at the intersection of CRT and TWAIL has located itself in that one subdomain of international law, human rights. But actually, international law doctrinally as a whole is about the relations between sovereigns. And when you think about the analog from the fiction of formal equality in law that exists at the domestic level and the fiction of formal equality among sovereigns that exists at the international level, what you see is a focus analytically on race domestically, that is the thing that is erased and obscured by that fiction of formal equality, and empire at the international level. So this relationship of race and empire is critical to understanding the places where CRT and TWAIL intersect, and in fact offer twinned analyses of analogous dynamics that are operating in the domestic and international spheres, albeit with very different objects of regulation. This is one of the many respects that CRT and TWAIL converge, but there's another thing worth noting, which is that CRT and TWAIL, and when I say TWAIL, I mean third world approaches to international law, emerge in the same moment from the influences of the critical legal studies movement on individuals thinking primarily with an analytic focus on race in the domestic context and thinking about empire at the international level, and they emerge around the same time. There's a critical period in the late 1980s and early 1990s when these conversations are coming to the fore in the legal academy and really preoccupying those who are interested in thinking, let's say, from below about the operations of law domestically and internationally. So what are the core concerns of CRT that, in my view, have these recognizable international correlates? And again, I just want to cite Tendai and I, who have written explicitly about this. CRT works to problematize and resist these strategies of erasure, right, that obscure the role of race in histories of expropriation, dispossession, enslavement, through the deployment of legal fictions like contemporary equality. CRT also explicitly addresses the politics of knowledge production, which is a key site of intervention, and that's what we're here to talk about. The think, transform, teach, all of this has to do with our ability to be agents in the process of knowledge production, resisting the silencing that actually occurs when we understand only certain kinds of voices to be privileged voices of authority capable of producing expertise. And finally, fundamental to CRT, as we heard last night, as a scholarly and intellectual community, but also an advocacy community, is that the work contributes to a reconstructive project, that there is a broader goal here that is that is implicit in the scholarship and in the training especially of those who will advocate for change, which is that a critique can be combined with a commitment to transforming within and through the law, even as intellectual engagements also appreciate the limits of a strategy to achieve change through law. So law and. We can use this tool, we can use other tools, we can inform social movement organizing, we can think critically with law, we can reconstruct law, we can move past law. Those are the moves that CRT has trained all of us in, including those of us who are lucky enough to be junior faculty here, and those are the moves that we can carry with us into the TWAIL project. So then to just say a couple of words about TWAIL, because Jerry instructed us to be very precise conceptually in defining our terms and making sure that we're not just assuming knowledge. So let me just say that third world is not the pejorative that people imagine when they tell me don't put this on people's transcripts, but rather it is that, and precisely because it is that, it is a tracking of the common experience of political, economic, and social subordination that has driven the use of the term to define whole geographies of subordination in terms that have become an epithet. And it wouldn't have mattered what you called it. You could have said Global South, you could have said Third World, you could have said, to quote, there's a famous advisor to Benjamin Netanyahu in Israel who said, let them call it a state. They can call it fried chicken for all I care. They can use whatever language they want. We're not going to allow them to be free. We're not going to allow them to experience sovereignty. And in many ways, the language, the choice of third world, which is to demarcate the idea that we don't stand subordinate to or with the first world, or at the time that terminology emerged, the second world, that language was immediately reappropriated to be an epithet in those places that we were defining ourselves as distinct from and against. And so that idea that we have a common subjective experiential site and locus that is not geographic, but is actually epistemic, is what is being validated by the idea, the phrase third world. And it is a site of knowledge production that defies the treatment of the West or the global North as the only plausible source of legal knowledge, which is what, of course, dominates all international law doctrinal production and scholarly production. It is also a site of diverse methodologies, and this gets to one of the points that this panel is really exemplifying, which is that also in CRT, we are talking about not just an interdisciplinary, but a multidisciplinary place in the production of knowledge that embraces, instead of treats as problematic, the fact that we can speak through many disciplines and address the same sets of analytic questions. And fundamentally, TWAIL is an anti-imperial and anti-racist project. So you can see the overlapping, obviously, premises and analytic foci of these two traditions, although they look oftentimes at separate phenomena. But here's an instance in which they look at the same phenomenon, and again, it has been foreshadowed by the comments on yesterday's panel and this morning by Laura, which is settler colonialism, which is an analytic concept itself that emerged. Obviously, the phenomenon is, let's say, centuries old, but the analytic concept of defining it as a distinct kind of colonial and imperial encounter emerged in the 1990s in academic studies in the global history of colonialism and post-colonialism, and traveled to CRT largely through a focus on indigeneity and indigenous studies here domestically in the United States, with race, again, as a central analytic focus in the study of settler colonial dynamics. But as more recently, you might have noticed, it has also traveled to the New York Times, or to all across our public discourse through the lens of October 7th and critiques of Israeli policies in Palestine. Intersecting that concept has been decried, has been over and over again disparaged, settler colonialism. And it has intersected not just with a virulent anti-CRT white supremacist politics domestically, but also has been specifically reinterpreted through anti-discrimination laws' weaponization, effectively treating settler colonial analysis itself as a form of racism, that is to say, as a form of anti-Semitism. And this weaponization and this set of moves crystallizes the reasons that actually settler colonialism is such an important analytic move. Because settler colonialism, defined per Jerry's request, as an imperial power colonizing a separate polity through a process that emphasizes the transplanting of a substantial home country population, termed settlers, to the new territory. And these colonies of settlement are then defined by economic, legal, and political systems that distinguish the rights and resources provided to colonists and their descendants, the settler insiders, from those available to indigenous groups or disfavored migrants. So what does a concept like this allow us to see? It gives us the analytic leverage to see continuities and discontinuities across historical periods through first wave colonization of what historians term the New World, that is to say, the Americas and the Western Hemisphere, and later settler colonial transplantations in the 19th and 20th centuries by Europeans in Africa and the Middle East, and indeed the Japanese in Korea and Manchuria, and allows us to answer very specific puzzles about both differences in racial construction across various polities, with aggressive segregation in some contexts and racial hybridity in other contexts, and changes in property ownership and land tenure over time, to just name two things, but primarily highlighting the transnational family resemblances helps us understand the movement of ascendant transnational white supremacy that connects the dots between an Israel and a New York Times reading audience, and South Africa, and Australia, and Canada, and the roles that this universe that is connected through these dots and through these histories is playing in the construction of the language that we can and cannot use as we witness apartheid and genocide unfold and are told not to believe our lying eyes, not to use language that describes what is actually happening, and certainly never to speak about the historical concepts that unite these experiences across these geographies and explain why some people find themselves moved to be in the streets or in encampments or raising their voice, and other people feel absolutely mobilized to silence and repress those who would raise their voices. So that analytic concept and the leverage that it provides us from CRT to TWAIL, driven out of a history of a particular kind of intellectual formation in the 1990s here, but now traveling globally, enables us to provide an analysis that reads that white supremacism as a transnational and global phenomenon. And by naming it and understanding it, gives us the analytic clarity to begin to think about how to organize against it, how to study it, how to analyze it, and ultimately how to resist and disempower it. And with that, I'm going to stop. Thank you so much.
Wow. Is this working? Yeah. Hard act to follow. I'm incredibly honored to be here, and I want to, like the other panelists, just start with my thanks to Jasleen and to Ida for organizing, to all of my colleagues here at CRS and all of you. I just came back from a couple of months in Europe, and it wasn't easy to come back to the United States at this moment, but I came back to be here. And I think it is kind of amazing that we are celebrating 25 years of this institution. So I want to go back even a little past 25 years to when I was in graduate school in history and in law school, which is now like 30 to 35 years ago, in the early 1990s, at that moment that Oslo is just talking about. So I started my studies at a moment when critical race theory was really just taking off and flowering. And I took my first summer after 1L. So I did my history coursework and exams, and then I went to first year of law school, and it's kind of a shock. I think to everyone who's a first-year law student, but coming from graduate school, oh my God, what have I done? And after the first year, I said, I need to take my summer off from not go work at a firm, and I'm just going to spend the summer reading critical race theory. And remembering why I'm doing this. And so I read Pat Williams' Alchemy of Race and Rights had just been published, Kim Crenshaw's Demarginalizing the Intersection of Race and Sex a couple years before that, Angela Harris, Mari Matsuda, all of these seminal works had just come out in the last, that year or the last few years. And that reading really shaped the work I did as a beginning legal historian even though very few people who identified as legal historians at that time, and there weren't very many, identified as critical race theorists or vice versa. But it was clear to me that CRT spoke directly to what I hope to do as a legal historian. And so I want, in my remarks, to talking about what critical race history I think is, or what those of us who do it have tried to do. I want to highlight the T in CRT, the theory, because legal historians tend not to talk about or think about theory. My colleague Alexander Arnold nodding his head. We were just talking about this. And I'm going to just give one anecdote about that. My very first talk or paper presentation as an academic, I think it was beginning of 1995 because I had a brand new baby. And Cheryl Harris and I were on a panel at Cardozo Law School. It was a symposium on slavery and the law. We may have been the only women there, right? And definitely the youngest. And we presented our work. Both of us were grappling with how to write about the way that law produced whiteness and how law produced subordinating racial regimes, and we were both engaged in recovering voices of people who weren't usually written about in law reviews, and we were both interested in telling those stories. And after our panel, there were two senior white male legal historians there. I won't name any names. One was in a history department, one was in a law school. And separately, each one of them sat down with me and said, I have no idea what either of you were talking about. And it was just basically irrelevant to what we do, like to legal history. We were speaking a different language. And so it was incredibly important to me as someone going into that field to have critical race theory as a resource when the rest of legal history and legal academia was telling us, we have no idea what you're talking about, and we don't care. So here are a few of the points I just want to highlight. Asla already mentioned this one. The phrase comes from Mari Matsuda, looking to the bottom. A methodology that attends to the voices of subordinated people who interacted with legal institutions on a day-to-day level, not necessarily high court opinions, right? In my work, I was trying to understand how enslaved and free people could shape the law, could make claims on legal institutions. We looked to practice, looked to law on the ground. All of that came from critical race theory methodologies. Second, narrative. History is storytelling. History is the power of stories. This was very counter to the norm in legal academia. And when folks like Patricia Williams talked about narrative in the law, that was incredibly controversial. There were reams of law review articles written to talk about why narrative is a really bad idea and shouldn't be a practice in legal scholarship. Third, a focus, and folks have been talking about this, a focus on the power of law in constructing racial categories and race itself. That there aren't simply Black people and white people and Latina people who exist out there, and then there's something called discrimination that one group does to another. The law itself produced race through technologies of subordination, and what I was interested in doing, and many of the people of my generation of legal historians of race and slavery wanted to do, was to show actually how law constructs race, what that means at the ground level for law to create racial regimes, and how at times even subordinated people relatively powerless in a society could use those tools to contest those processes, and how that really works, not the what, but the how. And I think historical methodologies have allowed critical race theory to really do that. And folks like Ian Haney Lopez, like Martha Jones, Dylan Penningroth, many of us were working on that. Fourth, the idea that racism and legal structures of race shift shape, and that racism is not only eugenics or biological racism or 19th century versions. In fact, that even in the 19th century, this was always scientific ways of understanding race as blood always went hand in hand with other versions of racism, what we sometimes call cultural racism. So some of what Laura spoke about, language, what Justice Kavanaugh was talking about as, if you work in this kind of job or you speak this language, we're not necessarily going to say that that's race, but effectively we'll make sure that we do the same work, and that race as performance and race as biology or blood have always gone hand in hand. And I think that connects to the fifth point, which is that much of the history, legal history, critical race histories, has been about the rise of colorblind racial ideology, colorblind constitutionalism, and how colorblindness operates to mask continuing structural inequality. Some of those histories talk about how overt white supremacist uses of law give way to colorblindness that does similar kind of work. But what I have tried to do, and what I think we're increasingly seeing now, is that these have actually always gone hand in hand, and they're not temporally distinct. The most overt and violent racist movements have always worked side by side with race-neutral and moderate legal mechanisms of oppression and so-called structural racism. That was true in the 19th century after emancipation, for example, with the rise of vagrancy statutes, various forms of criminalization of poverty, or the variety of legal mechanisms to suppress the vote that go hand in hand with violent racial cleansings of towns and cities with massacres and lynchings. It was true during the Second Reconstruction, and it's true today. So we shouldn't be surprised, I think, at the resurgence of overt white supremacy at the same time that we still see the court talking about color blindness and applying it to everything from voting rights to higher education. In my last minute or two, I just want to say we're at a really important juncture right now for critical race histories to help explain the rise of fascism in this country, and especially to explain that what we're seeing now has an indigenous history. It has its roots in a U.S. history of anti-blackness and white supremacy, although of course that is also a global history. There is a global movement of the far right, but here I think we can see we can trace that history to emancipation and its aftermath. And so the work that I have been doing recently, and together with folks like Carol Anderson, Nancy McLean, and history departments, and a number of folks on law faculties, is really the effort to show not only the roots of the current crisis in our own history of slavery and racism, but how that history is being erased. And we've already been talking in last night's panel, and as well as the previous Race and Law Network discussion about how important that erasure is. And I'll just end with this, right? I think critical race histories and historical methodologies are key to a moment when the anti-blackness of fascism is being erased, and our job is to bring that back to the fore. So thank you.
Thank you. Oh, great. Good morning. Good to see you all. It's always a joy to come home to UCLA CRS and to see the beautiful faces of old friends and new friends. This just fills my soul. And thank you to Latoya and to Jasleen and Ida and everybody who's organized this event. A central contribution of CRT has always been a critique of the limits of anti-discrimination law, and Kimberly Crenshaw's work on intersectionality is at the leading edge of that body of scholarship. Kim centered Black women in her analysis in order to contrast the multidimensionality of Black women's experiences with the single-access legal framework that distorts these experiences. She revealed that anti-discrimination law's reliance on a single-access analysis, race or sex, but not both, limits its ability to understand discrimination and effectively remedy it. So Kim's first article on intersectionality critiqued a judicial opinion involving Black women who sued General Motors. In 1976, Emma DeGraffenreid sued GM, arguing that the company segregated its workforce by race and gender, and there was a distinctive intersectional impact on Black women. That is because the Black jobs working on the factory floor were designated as the men's jobs, and the women's jobs, secretarial work, were set aside for white women. Thus, Black women fell through the cracks, being deemed ineligible for Black and women's jobs. The plaintiffs brought a claim under Title VII, the federal anti-discrimination law. Judge Harris Wangelin, a white man, declared that the plaintiffs are clearly entitled to a remedy if they have been discriminated against, he said. But then he said they were not seeking mere equality. Their claim that they had been discriminated against as Black women, quote, would combine statutory remedies to create a new super remedy, which would give them relief beyond what the drafters of the relevant statutes intended. The judge even claimed that a new classification of Black women would give them, quote, greater standing than Black men. So I'm going to argue that that's actually what white men in the anti-DEI movement are seeking today. Like, they want a super remedy. I haven't even made the argument yet, and you're already applauding like, this is my room, okay? They want to carve out a new doctrinal lane just for them, and maybe white women can get into, right? But not for the rest of us, right? They want to, and I've been trying to figure out, like, what is the right analogy or term? I don't know if it's cultural appropriation or gentrification, but like, it's taking intersectionality and structural racism and creating it for white men, okay? So an empirical analysis by Rachel Kahn-Best and Lori Edelman found that plaintiffs who tried to bring intersectional claims were only half as likely to prevail as those who brought a single access claim of discrimination. And the study also found, and when I read this, and I'd read it years ago, but you read things and you forget, and then you come back and you're like, wow, that's astonishing. They found that, they studied over 1,000 cases, and they found that 36% of white male plaintiffs won, 35% of white women won, compared to 13% of non-white women. So this suggests that Title VII has a bias in favor of white men and white women. People applying intersectionality or critiquing it often reduce it to a theory that is only or largely about Black women. Crenshaw, however, has persuasively contested this reduction of intersectionality's scope and relevance. And recent work by Devin Carbato, who I can't believe he's not here, but I had to just summon him into the room. Carbato wrote this great piece called Colorblind Intersectionality that argues that the dominant way of theorizing intersectionality erases the racial intersectionality of white people and makes it easier for whiteness to operate as the natural and unmarked racial backdrop for other social positions. So some of what I'm trying to do in this project is also think about the intersectionality of whiteness. Surely one could argue, given the historic roots of intersectionality in Black feminist theory, that it does not speak to the experiences of the most dominant group. But I think what they're trying to do in the anti-DEI movement is recast a little bit less dominance as racial subjugation, right? And we have to contest that. Now, in Demarginalizing, Kim's first article on intersectionality, there was a footnote where she observed that she had not found any cases where a judge said that a white man bringing a reverse discrimination claim had to meet the sort of barriers in terms of disaggregating the claims the way that Black women were. And in doing another search this year, we still can't find any cases, right, where a white man has been told it's race or sex, you can't have both, right? So that in and of itself shows a disparity. But it goes beyond that, right? So, and I should say we are in the very early stages of this project, so everything is tentative. But I did want to kind of show you where we're going, right? So the bias may not simply be that white men can glide past the doctrinal traps that have often limited relief for Black women plaintiffs. We have found some cases suggesting that judges allow white men to win at summary judgment based on evidence that minimizes anti-Blackness and treats the pursuit of diversity as inherently anti-white. In Jenkins versus Nell, a white male crane operator at the Georgia Port Authority asserted that his Black male supervisor fired him because of race. The two had had a heated exchange over Jenkins' request for leave, but his boss said nothing that was racially coded or nothing about race at all. Nell, the boss, said that he ordered Jenkins to clock out after their argument and leave the workplace, but Jenkins refused. He said that he fired Jenkins for insubordination because he refused his order. Two Black former employees whom Nell had terminated testified that Nell previously made comments that he believed that the white crane operators in his department were racist and unwilling to work for a Black man. One former employee testified that Nell specifically referred to Jenkins and another former crane op manager as racists. And in fact, Nell had said that the meetings, the social meetings of the white crane operators were basically Klan meetings. Both the district court, a white man, and the 11th Circuit treated these remarks as evidence of anti-white bias by Nell. This is Georgia, okay? And I'm from Georgia, but my family's from Georgia. Neither considered whether Jenkins and the other white crane operators were just racists, right? And then in Ritchie versus Napolitano, a white Secret Service agent during the Obama administration argued that he was denied a promotion because of his race and sex. Now, mind you, at this point in time, and I love this photo, but it's like the Secret Service was extremely white male, right? And the decision maker in Ritchie's case actually said that he chose the most qualified candidates. But the district court judge held that the manager's statement that he, quote, saw value in diversity and considered it as one of several factors in selecting the best candidate was sufficient by itself to show anti-white bias and entitle Ritchie to a jury trial. And it gets worse. The judge in Ritchie was a Black woman, and the 11th Circuit panel in Jenkins included a Black man, a Latino man, and a Latina. So this raises hard questions about how do you debias anti-discrimination law when the judges themselves may have internalized these biases, or, as Devin Carbato has said, maybe they were engaged in identity performance to demonstrate their neutrality to their colleagues. A shift in the broader culture might lead to a surge in white men claiming to be victims of discrimination. The Me Too movement, beginning in 2017, and the racial uprising of 2020 fueled an uptick in race consciousness in society, including among white men. A turning point, remember this? A turning point was when Judge Brett Kavanaugh denied sexually assaulting Dr. Christine Blasey Ford during his Supreme Court confirmation hearings. Although Dr. Ford was initially regarded as a credible and compelling witness, and I remember this vividly, like how liberals were like, wow, she was amazing, this is gonna all work out. And then Kavanaugh, flips the script, right? And he's unhinged, he talks about beer, and yet this was compelling to people, and it changed the conversation too, but what about innocent men, right? This is what Kate Mann has called empathy. So this sort of competitive victimization is, I think, a really helpful frame for thinking about what's happening right now. Me Too and the racial uprising made it more difficult for whiteness and white maleness in particular to hide in plain sight as an invisible baseline. Discussion of structural racism, white privilege, and intersectionality was ascendant. Young social justice activists were calling out white cis men so much that some such men said that phrase should be understood as a slur. And during the Kavanaugh hearings, Senator Lindsey Graham asserted that he was told to shut up because he's a, quote, single white man. There's a lot I could say about that, but I'm gonna move on. During a 2021 episode of his popular podcast, Joe Rogan, while in conversation with another white man, argued that cancel culture and wokeness were becoming so powerful that, quote, if you get to the point where you capitulate, where you agree to all these demands, it'll eventually get to the point where straight white men are not allowed to talk. Rogan would go on to evade an effort to cancel him over his use of the N-word, to play an influential role in the 2024 election, and to lead Democrats to pine for a liberal Joe Rogan. Liberal and progressive white men have also invoked their identities in a defensive way. Bernie Sanders, at a debate, was asked, should old men step aside? And he said, and I'm white as well, right? Frank Bruni, a New York Times columnist, wrote a piece called I'm a White Man, Hear Me Out. And he asserted, my gayness no more redeems me than my whiteness disqualifies me, and neither, I hope, defines me. And so part of the project is trying to figure out how gay white men figure in this moment, because we kind of see them on both sides. So none of these folks invoked intersectionality, but they basically were appropriating it for their own purposes. And now we're seeing this movement become government policy. Oh, and Pete Buttigieg, right? Oh, yeah. So, got to bring up Mayor Pete. What we're seeing is the Trump and Vance administration injecting what they call DEI into every conversation, right? The Potomac crash at the beginning of Trump's second term. That Trump and Vance blamed Buttigieg and Obama and claimed that they had ruined the agency with all their diversity. And we saw it, of course, in LA, you all remember this well, with the wildfires and the claim that Mayor Karen Bass and the fire chief, a white lesbian, that their DEI was responsible for the tragedy. So the overall effort is really to try to fuse competence with white male identity, even when there is clear evidence of ineptitude. And then to write this into law, and if I had more time, I'd talk about some of the strategies to write this into law, but I will stop there since I'm at time. Thank you.
All right, we started a little bit late, so we're going to go a little bit longer, and for that I'm deeply thankful. I'm going to start some interesting conversations, and then hopefully we'll get a little bit of rounds in for folks out there in the audience. Really thoughtful conversation already. Maybe I'll pick a fight starting with this. So, the truth of the matter. Does the truth of the matter matter? We heard last night that in some sense, I'll call out to Derek Bell, that again, if you want hope, you need truth. So the truth of the matter matters, presumably, but for those of us who started critical race theory back in the 90s, right, there was a whole contestation of what truth might mean. If you actually privilege, for example, views from the bottom, if you actually adopt a post-structuralist frame where you see everything really about power, not so much as truth, there's a genuine conflict about what it is that we're doing. Is there a truth of the matter? Can we find it? Do you seek it, or is it just flexing power whenever you can? And part of that is latent controversy in the methods that we use. So like Ariella, you talked about narrative and how significant it was. You talked about actually privileging voices from the bottom. That can be a way to get at a deeper truth, intersubjectively. It could also be a recognition that like the truth game doesn't really work. It has never worked. And so then it's really just about getting power so that you can actually defend your own. So I want to hear a little bit about the nature of truth, and whether going to other communities who are sometimes ignored, whether they be outside of the domestic U.S. boundaries, other communities who are in some ways underprivileged, when we say, oh, we're associating competence with white maleness, when the truth of the matter might not be so. I want to understand your relationship to the truth of the matter as you exercise critical race theory. So, Ariella, start.
Yeah. So I think, like many of us, I think this is a tough question for us, and I will say a couple of things. So first of all, in the current project that I'm working on, which is about the way the current court and administration, but also the court since emancipation, has been erasing the memory of slavery and racism from the Constitution. And of course, their version of constitutional memory, right, their fantasy of the colorblind Constitution that with its timelessness isn't the only story. There have always been these counter stories. Even if you took an originalist frame and said you wanted to recover the original meaning of the 14th Amendment, there are much broader ways to understand it by attending to those different truths that come from widening your lens to different, to folks who weren't in that room voting on ratification. But and in the past, I've written about this with an agnostic view about the truth, that I was going to, this is, there are better and worse stories. Let me tell you about the competing stories, and I can tell you which one I like better. And when as I started to write this book in this moment, I ended up, and here again, I think I have to call out my colleague Alexander Arnold, because he was one who really told me, have the courage to tell your story as the truth. Use the authoritative voice of the historian to say, this is my story. It may not be the only, this is my truth, that this is what actually happened, that enslaved people seized freedom themselves, that freedom was not a gift from white people to black people.
But Ariella, interrupt. But was that decision, right, courtesy of an editorial suggestion from one of our colleagues, is that performative in the sense that you think that's how it lands best to the audience to achieve the results that you want? Or is it because it is the truth? I'm probably still enough a creature of the critical movements of the late 80s, early 90s to say I'm not going to wed myself to that there is an objective T truth out there. But I still think that that our endeavor to reach the best version of the truth we can, and the fact that we're committed
to the methodology, the scholarly practices and methodologies that are about finding the truth or getting closer to it, whereas the truthiness people are not committed to it at all, right? Our practices are much better than theirs, and we're getting much closer.
So I think this is super interesting because it is a reflection about different methodological commitments that lead us to something that is more insightful and maybe in some ways true. Asla, I feel that you want to jump in.
Yeah, so I think this question, first of all, I just want to say the move of being like, we have a couple of minutes, so let me just ask one little question. Also, let me cold call the panelists to answer in the order I choose. I just want to mark the Jerry Kong moment before I continue. But, okay, so in the tiny minute we have, what is truth? Let's see. Let me give two examples.
You speak fast. You speak fast.
Let me give two examples. I mean, so I said, like, we have to be an epistemic site, right? We are a site of knowledge production. And the question is, like, there are levels at which we can speak of truth or truths or a truth in a particular context. Here are two empirically contested claims. One, there are no civilians in Gaza. Two, we are striking in a war against drugs by missile boats of drug traffickers. Okay. Can we make truth claims about these two empirical facts? Would it be the same thing to say that the truth claim I have to make about whether there are civilians in Gaza or whether the object that is being struck militarily is either in the context of a war or indeed people that are engaging in narco trafficking, if we can even know that. When I contest those things, I'm making empirical claims about the here and now moment. That's a different kind of truth claim than the claim that there may be multiple ways of knowing Rashomon, right? What has happened in a particular historical time that are nested in one another. And if you narrow your lens or you expand your lens, there are multiple stories to be told. We are sites of epistemic knowledge production, to me, because we can operate at both of those levels. I have a thing to say about whether there are civilians in Gaza or whether children that are Gazan are capable of being treated as protected categories, and I will argue that that is a truth claim that I will stand behind as the truth in an empirical moment and a narrow kind of epistemic thing. On the other side, on the Caribbean Sea becoming a militarized ocean, I will tell another truth also. I will tell the truth that Obama administration officials decided that they could use statistical information to demographically rule men in territories far flung around the world terrorists and extrajudicially assassinate them, and that enjoyed bipartisan support. And today, when you have Trump using exactly the same logic written by the way, far supposedly left-leaning American international law scholars who today denounce Trump, when he uses that same language, suddenly they have a critical lens. And they don't want to see the truth of the trajectory that connects the analysis they provided on a bipartisan basis for exterminating American citizens in Yemen to the lineage that clearly now enables the militarization of the Caribbean Sea. That's a different kind of truth. I'm going to say that they would treat that as a truth. I'm still going to defend it, both of them on truth claims, able to understand that epistemic, the knowledge production and where you sit epistemically is a political question that doesn't necessarily undermine my ability to claim truth in either of those moves.
So there. I'm going to remember from that there are always levels to the game, and so I appreciate that. Can I just? I know that in part because I want to just get a few more thoughts from Laura and Russell. You could address that question to the extent that you're interested. But one way to think about this potentially is a question about accountability. Like one thing that we're constantly doing when we say, oh, there's a contradiction here, when you said that you did not like intersectionality here but are actually invoking it here, that seems to be in some ways a contradiction. And unless you explain that contradiction away, I'm going to hold you to account. You claim these things as empirical claims. I have empirical evidence to counter that, so I am holding you to account. So accountability is something that we often do, including you say that you're fully inclusive and you care about all peoples, but maybe you're not thinking about this people in this way, in the same way, when I think they should. It is one strategy of creating accountability, and part of what we do, I think, as scholars is to hold people and power to account. So I want you to address any part of the truth conversation. If accountability is one way that you could think about things, I'd love to hear your views on that. And then I'm being mindful of time because we have literally 5 minutes left.
I will just say a few words. Can you hear me?
Closer.
How about that? Yeah. Okay. So this is, I think, somewhat relevant to both of your difficult and big questions. And it actually goes back to the beginnings of CRS and why we are named the Critical Race Studies program as opposed to the Critical Race Theory program. There were two reasons for this choice that we made, the group of us, 7 or 8 of us, back in 2000. And one of them was a tactical choice. We were presenting a proposal to the UCLA Law School faculty to create a new program, the first specialization at the law school, before business law, before the environmental law program, et cetera. And partly it was trying to anticipate that we were going to have a very close vote, and that if we said critical race studies, that might actually get us over the hump. The second was actually substantive, and I think it relates to the two questions that you're asking, which is some of us said, where is the theory in critical race theory at that time? And we didn't necessarily feel that the field as it had developed in that first generation was necessarily about theory. The other was also about multidisciplinary work, interdisciplinarity, transdisciplinary work. And that was that we looked to empirics for some of the questions. Certainly your work, Jerry, on implicit bias has done that, is that we are looking to, at some level, let's not just cede to the other side the hard data or the numbers, that we actually can bring that in as well. So we could have the narrative stories, but we could also have the quantitative studies, but also other kinds of empirical method, including qualitative method. And so I think that's an interesting part of the conversation.
Excellent. And you should also know that we were invited to call it the Race and Law Program, and we also decided, hell no.
To get more votes.
Yes, to get even more votes. And so all you need is N+1, so we got 51, so we're good. Russell, any response?
I would just second everything that Ursula said, which I was just super brilliant. So thank you for that. But I would also say I think we have to grapple with the truth in this moment after another election that favored Trump, that telling our truth may not be enough to persuade even people that we think are in our camp. Right? I was in the airport not too long ago, and I heard a black man objecting to the No Kings March. And I thought, okay, we got people that are in the family that don't understand what is happening. I have a MAGA cousin, right? A black man who voted for MAGA, right? And blew up the cousin chat, explaining why. Right, so we can know the truth, but I know that it's not enough to just start, sending him my articles, right? But we have to sit with them and listen to them and understand how they have accepted alternative facts, alternative truths, and try to figure out how to reach them. That is hard, messy work that, frankly, I don't think any of us want to do, but we have to if there's a future for our democracy.
Thank you. Hey, so Jasleen, should I stop now because I see the dean, a very important person, who's going to speak soon? Close it up or? Okay, so number one, I apologize. No doubt you had multiple questions. You could haunt them, throughout and stalk them as necessary to ask your questions. Number two, I just want to underscore just the little sampling of, frankly, intellectual delight that is possible from this practice. And I am humbled not only by the community, but by just the raw smarts here, just the raw firepower that you see. And even if we understand value in its multifaceted ways, we are also a university where our commitment is to think new ideas and to challenge each other with different conceptions of truth at different levels, and ultimately to hold all of ourselves to account. And maybe I can close with this. Holding other people to account, holding power to account is best done when we also hold ourselves accountable to the possibilities that we might be wrong, to the possibilities that we could hear each other and say, holy shit, that was the smartest thing I've ever heard. I am changing my views. And that practice, leveraging everything we know from every discipline, is the only thing that we could actually possibly do in this moment, to hold all of us to account to a vision of a more basic, just society that we hope to leave the next generation with. Thank you very much.
Hi, everybody. Okay, I realize at this point I'm the last thing standing between you and your break, so I promise to be quick. Did Jerry just say shit? Am I the only one? Hi, my name is Michael Waterstone, and I have the honor of being Dean of UCLA School of Law and welcoming you to this incredible event, marking the 25th anniversary of the Critical Race Studies program and honoring all of the people that have dedicated it to its success. It seems like my life involves parachuting in and out of events that I wish I could stay longer for. I just came from LAX, and I'm actually doing this and then heading back out of town. But I really wanted to come briefly and at least say thank you for being here and offer a few remarks on behalf of the school. So really, three main thoughts. First, I'm really proud to be in a state and in an institution that doesn't just allow a conference like this to happen, but supports it and celebrates it. I think particularly at this moment, I don't take that for granted. And I'm just so grateful for the work that all of you do and coming here to be a part of our community for this important celebration and event. Second, I wanted to note what a point of pride our CRS program is for UCLA Law and UCLA. And I know that there have been conversations, and there will be more, addressing the founding and evolution of CRS over the past quarter century. And certainly the launch of the program in 2000 was a major moment for UCLA Law and in higher ed. And we pay our respect today and celebrate the founding faculty members, most of whom I think are here today. And I just want to note from an institutional perspective, these are some of our incredibly valuable institutional citizens that, apart from building the CRS program, built UCLA Law into what it is today. And I just want to, on behalf of myself and my predecessor deans, note and acknowledge and say thank you for that. And third, I get to see the impact that CRS has on our students and our alumni. It's extraordinary. It's a huge recruitment tool. I apologize to most of you at other law schools. I'll say that again. It's a huge recruitment tool. I was up in the Bay Area until this morning meeting with, amongst other things, a donor who CRS sparked his interest in what he's doing and led him to want to give back to the school. At any given time, there are about 200 students across all 3 years of law school and our LLM program specializing in CRS. And these students graduate, and we now have generations of graduates at UCLA Law and CRS working as faculty members here and elsewhere, teaching others in law schools. And they and you continue to be on the front lines of advocacy and fights for equality and civil rights. So I joined UCLA Law only about 2 years ago, but I've long recognized and known and admired CRS at UCLA, what it stands for and what it is. And our colleagues, and many of you in this room, have consistently stood up. You stood up after George Floyd's murder. You've stayed strong amid a barrage of attacks against critical race theory. And now, with pressures coming from the highest levels of law and government. So thank you again, everyone, for joining in this symposium, this celebration, making a difference, fostering change, and supporting the Critical Race Studies program here at UCLA Law. Thank you.